हेलो एंड गुड मॉर्निंग एवरीवन। आई होप यू आर डूइंग गुड। आप सभी की LLB की प्रिपरेशन बहुत अच्छी चल रही होगी। गाइस, दिस इज़ अवर सीरीज वेयर वी कवर द लीगल स्टैटिक जीके फ्रॉम द पास्ट 10-year क्वेश्चन पेपर्स, and this is the part 3 of that particular series. Part 1 and part 2 are available on our channel. You can check out their link in the description box. Along with that, the handout of the today's video is also available on my Telegram channel. The link is in the description box. You just have to check it out. And today, before we start the video, if you are new to the channel and you haven't subscribed yet, make sure you subscribe to the channel and hit the bell icon so that you won't miss any of our future update. With that, now start with our first question. Question number first says that who was the judge who held that fundamental rights were not amendable? Alright, so this is a very tough question, by the way. I am just warning you. It is a tough question. You know that fundamental rights are amendable. Right now, the legal position in the Keshavananda Bhartiya case is that fundamental right can be amended as far as they do not violate the basic structure. It means that this question is before the Keshavananda Bhartiya case. And you tell me which was the judgment before the Keshavananda Bhartiya case, which was the landmark judgment before the Keshavananda Bharti. It was the Golkanath case. Alright, Golaknath case. In this case, Supreme Court of India in its 11-judge bench, held that fundamental rights cannot be amended. In these 11 judges, there were 5 judges which gave judgment in favor. There is one judge who basically concurrence, who doesn't take any side. Then there was 5 judges who basically give the dissent opinion, like they were not in this particular favor. So these were 5 judges, like 1, 2, 3, 4, 5, who gave this judgment that fundamental rights are not amendable. So the right answer is option number D, that is Justice K. Subbarao. It is B, so just make it correct. Justice Subbarao. And Justice Subbarao was basically part of these 5 judges who held that fundamental right cannot be amended in the Golkanath case. It is a very famous case. So you see, how can they ask you the question if they want that the student will not solve the question, you will not solve the question. ठीक है, अगर एग्जामिनर सोच के आया है कि ऐसा क्वेश्चन बनाना है कि बच्चा सोल्व ही ना कर पाए, यू कांट सोल्व इट. ठीक है, आई नो यू कांट सोल्व इट. सो ऐसे क्वेश्चंस आते थे, आते हैं एंड आएंगे. So if you get a question like that, don't be panic, don't be nervous, because these questions are intentionally put to make the question paper hard. Alright, so don't be panic with these questions. Now coming on to question number 2. Question number 2 says that which among the following cities does not have a bench of the National Grand Tribunal? And in our part 2 we have covered this question. But again, I am repeating that NGT is having branches in the 5 cities, and the city in which NGT is not having branch is the Ahmedabad. Ahmedabad के अंदर branch नहीं है. Apart from Ahmedabad, in Chennai, in Pune, in Kolkata, in all these 3 states, in all these 3 cities, the NGT is having its branch. And apart from these 3, if I have asked you that what are the other 2 cities in which NGT is having its branch, so the right answer to that question shall be number 1, New Delhi, and another city in which there is a branch of the NGT, and that is the Bhopal. Alright, so these 5 cities are having the NGT branch. Now coming on to question number 3. Question number 3 says that the legal branch of the Indian Army is known as, and the right answer to this question is option number B, that is the Judge Advocate Journal. You know that there is a entry for law graduates into the Indian Army. So after you complete your LLB degree, you are having a chance to serve the nation by joining the Indian Army through Judge Advocate Journal. It's a great opportunity for the law graduates. So answer is option number B. Now coming on to question number 4. Question number 4 simply says that in taking and recording evidence, the language of every court within the state other than the High Court shall be. And now see, it is determined by the respective state government. Alright. For example, I live in Uttar Pradesh. So in Uttar Pradesh, the language of local court is Hindi. And it is basically determined by the respective state government. So you know the answer, you know the crunch. So it is decided by the respective state government. Now coming on to question number 5. Question number 5 says that in which of the landmark judgment did the Supreme Court of India lay down guidelines against the sexual harassment of women at workplace? It's a very famous case, and I expect my students, I expect my audience to mark the right answer to this question. So just pause the video, think a little bit and mark a right answer. I am having a lot of expectations from you guys. So the right answer to this question is Vishakha judgment, Vishakha versus state of Rajasthan, option number B. So it was the case of judicial overreach, where judicially basically come out of its domain and make a law. So what happened in this case is, at that particular time there was a lot of incidents of sexual harassment of women at a workplace, and whenever a woman go to the Supreme Court for the justice, you know what the Supreme Court says? Supreme Court says, sorry, we can't help you because we are not having any law for that regard. So the Supreme Court has reminded Parliament again and again that you have to enact a law. Supreme Court reminded Parliament, has requested Parliament to enact a law in the context of sexual harassment of women at a workplace, but Parliament didn't act at all. Alright, Parliament didn't act any law. So finally, in the case of Vishakha versus state of Rajasthan, the Supreme Court says we are laying down the guidelines. So Supreme Court point out certain guidelines and Supreme Court says that this is the law. Supreme Court says that let the Parliament sleep, and until and unless Parliament do not enact a law, we are issuing the guidelines, and this is the law of the land in all these sexual harassment case. So the Supreme Court give you the guidelines and those became a law of the land, and later on the Parliament enacted a law. So this is a very famous case. Just read it if you get a chance. If you ever get a free chance, just read a full judgment of Vishakha versus state of Rajasthan. It is an overwhelming experience of reading this particular judgment. You have to read it. Then coming on to question number 6. Question number 6 is that which of the following theory of crime is based on the works of Henry Mackay and Clifford R. Shah of the Chicago School of Thought? And the answer is option number A. Very static question, just have to mug it up. Now coming on to question number 7. Which of the following is the oldest high court in India? And the right answer to this question is option number B, that is High Court of Calcutta. High Court of Calcutta. So it was basically formed in 1862. It is the oldest high court. And again I'm giving you the question. You have to tell me which is the latest high court, newest high court. Newest high court. Just let me know in the comment box. Another question is question number 8, and it has repeated 2 times. It simply says that which of the following bodies is entrusted with the statutory duty to lay down the standards of professional conduct and etiquettes for advocates in India? We all know this, very simple. Bar Council of India, option number B. Now coming on to question number 9. Question number 9 says that a first information report FIR for a cognizable offense may be lodged by. Now there are 4 options. See, it can either be lodged by the victim, by the family member of the victim, or by the police officer. So it can be logged by any of them. So option number D is the right answer to this question. And now moving on to the last question of the today's video, question number 10. Question number 10 is the latest question of 2021, and it was again a tough question. So it says that noise pollution was included in the Air Prevention and Control of Pollution Act 1981 as a pollution in the year. So ये सिंपली बोल रहा है कि नॉइस पोल्यूशन को इस पर्टिकुलर एक्ट के अंदर कब इंक्लूड किया गया था. सो It was included in the year 1987. So option number B is the right answer. So you see the questions, you see the level of questions they ask. So that is how we have to prepare the past year question paper. That is why I always emphasize more on the PYQs, because they give you the glimpse of exactly what do you expect from its student. So with this we have completed the part 3 of our series Legal Static GK, and the 7 more parts would be released in this series very soon. And if you guys like my content, then I hope you will like the video, subscribe to the channel, hit the bell icon, and if you guys remaining with any doubt, just do not hesitate to ask me in the comment box. If you are having any personalized doubt, make sure you ask me through email or through Instagram. I would be available on the social media handles. The link of the same is in the description box. Just check it out. एंड इसी के साथ मिलते हैं नेक्स्ट वीडियो में. जब तक के लिए टाटा बाय बाय, सी यू सून, शाइनिंग ऑफ.